substantial or material prejudice against the defendant.
All right, so here we are. By the way, hello everybody. This is the Darrell Brooks. I like to call it a debacle because essentially that's what it was, given where he ended up. I don't know why he thought that it would be optimal for him to represent himself. But I think strategically there was a reason behind that for the purpose of getting a mistrial, as everybody should be aware of, because he knows he's not an attorney. And that was his way of potentially having this overturned in the appellate court. But it backfired. It backfired because Judge Duro was very intelligent and she was able to catch on to the gambit that he was trying to utilize. Saw right through it, and so that's why we got a result. Well, he got the result in terms of 7,000 years in jail. All right, let's see what his response is going to be here as the state had given their response. Let's go.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Uh-oh, here we go. No, he acting like
Just briefly skimming through it.
he's so concerned. Oh, please.
I do want to state for the record that I have no involvement with this.
Oh, really?
I'm really like shocked like this even came to light. I will say just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or
No, wait a minute. Why would he use the term common sense? I mean, anybody can challenge back and say, well, common sense can tell you that we are live streaming and somebody else could have heard all this and probably put that Reddit post up. So, I mean, why would he use such a word, common sense? Did he forget that they were live streaming?
a jury member. It's no other way.
Well, actually, the proceedings are live streamed
Thank you.
worldwide, Your Honor,
Thank
available
you.
on YouTube worldwide. So
Thank
I
you.
don't agree with that assessment.
I don't agree with it either.
Well,
That
it's
debunks
pretty
it.
obvious that
No,
this
it
would
ain't.
come from somebody who's actually,
You just got debunked, man. Shut up.
I think it's pretty clear.
Nah, it ain't pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court.
And the other thing about this is that it's speculative. So she wasn't able to just rule on it anyway. Um, it's being investigated. But I think um, the argument the prosecution or the state brings is just more valid. I mean, it makes more sense. This was being live streamed. Anybody could have written that post, you know. And then also there was a sequestration. The jurors didn't have access, you know, to any type of electrical apparatus to even post anything. So it just didn't make any sense. But of course, that was his tactic. All Darrell Brooks' tactics never made any sense. So I'm not surprised. Let's keep it moving.
So with that, the courtroom, oh, go ahead. I'm sorry. Something else, Attorney Hopper?
A different topic, Your Honor,
Oh,
if
sure.
possible.
Go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
I'm willing to discuss that. Do you have any position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Now, can I say something? Do you think the state would present anything in terms of an exhibit that's not relevant? So what does he mean, the relevancy? Come on, if it's an exhibit, then obviously it is relevant. They wouldn't just be bringing something in the absence of relevancy. This, God. Like, in other words, the state, they're not as dumb as he is. Of course, he would bring something that's not probative, that doesn't carry relevance. But why would the state be on his level of non-intelligence? Come on, man.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the
Thank you.
admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room. But
Wait, can I say something? Now let me ask you a question, audience. Wouldn't now he just asked about relevancy. Now, if that vehicle that he was driving, all right, which is used as indicated by the judge of the instrumentality, in other words, the mechanism, wouldn't that vehicle that is being alleged that he had driven that vehicle through a parade, wouldn't that be relevant? So why would he ask, the relevancy of that exhibit? Of course, that's the vehicle that's being alleged that you drove. Why wouldn't it be relevant? For even a jury view, or I mean, just across the board. I mean, come on. Is he this stupid? Ah.
simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time. So that does require the parties to be in court.
Now watch this. Now, if there wasn't a jury view, if the state didn't have the instrumentality that has been alleged that he had driven, then Darrell could argue, well, that's speculation. They're bringing up that where's the vehicle? They don't have it. That's facts, that's facts, not in evidence. So obviously it has to be relevant. They're bringing the evidence.
That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No. I'm talking about
He
a
is
video.
dumb.
We have the ability to play it directly. There's a TV. I should have said that. Probably not too. Why would you know there's a TV in the jury room, right? So there's a TV
Why
monitor
would he know
in
anything?
the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time.
He wouldn't know that. He's only an attorney.
But as far as other exhibits,
So it would be only the exhibits that's been
received.
So
Correct.
nothing new. Nothing's going to come out of the blue and be like, yo, yeah, we're going to.
only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received. If you
The only thing that's going to be new is what he didn't view in that discovery. All right. Just like, remember, he got upset because they had videotape of him, all right, and that from the still photo that he questioned Detective Casey. Well, he kept on saying, "Oh, wait a minute, that wasn't in it." He said it wasn't in Discovery. He didn't have it. Well, the reason why that was new is because he didn't review it. He didn't go through all of that. So the only thing that would be new is what he didn't review. Does that make sense? Ah.
like,
That's about like 7,500.
there's a lot of exhibits,
That's a
but
lot of
I don't
exhibits.
find
I'm
nothing
willing
funny
to have her
about that,
printed
man.
off if you would like it.
I don't
I
find
think
nothing
it'd be
funny.
helpful just in case. I'm guessing at some point that will come into play.
Right. For example, they may come back and say, we'd like to see Exhibit 15, which is the map, the large map of the parade route, okay? They might want to see the other map. Maybe they want to look at a video.
And the other thing is, how can he even laugh? Like, bro, you are in so much turmoil. You are facing a slew of charges, man. This is not lightweight. How can you even find humor? I mean, I even was wondering that during the interrogation when Detective Carpenter, and he's just like laughing, like, you just killed these people. How do you even laugh about anything? I don't get it. How did he just laugh just now? That's about 7,500. Like, how can you laugh about that, man? And I didn't really like how the judge engaged in that too. I mean, she should have just kept a straight face. Like, nah, I ain't getting into that.
The exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate. That's what the state, I think, was trying to get at. So do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough. Anything else, Attorney Opper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay. Thank you.
So
Wait.
that will depend on when it is, if it's
Yep.
late in the evening versus during the day.
It ain't gonna take long for the release of those verdicts. That's for sure. What didn't they return it? Didn't they say that it was returned within 2 hours? And I think the only reason why it was even that long is because they had to fill out all those forms. It was a lot. He didn't just kill one person. It was 6 people, plus the many that were injured. So it could have been a lot shorter than that if it was one person, because the evidence was stacked against it.
And you might be wondering, how late will I let them go tonight? Honestly, they've been at our schedule for 3 weeks.
Yep.
I will let them dictate how late they want to go tonight. When they tell me that we're done for the evening, they'll come back in. I'll read them the instruction about they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And they would go again where they are being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay. Thank you.
You're welcome. Anything else from you, sir?
Did you talk to the deputies? Or
I
whoever
did.
need
Thank
to
you for
talk
that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later.
He ain't had a
if that's
shower.
helpful, whether it be tonight or tomorrow morning, okay? So even though you're gonna stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So I've been
Then I'll
told
have
there
to-
is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction.
Oh my God, here we go with this stuff.
You knew I was about to say that.
See, I don't think. I'm sorry, y'all, and I might get in trouble for saying this, but I don't like the how Judge Durrell is feeding into it. Like she shouldn't be laughing. You know, he been arguing that the entire time. That is BS. Subject matter jurisdiction is BS. You know, how many times does she have to keep, refuting that? It's not getting him nowhere. And then he laughing, and it goes back to my point. How can he even laugh? Come on.
Sir, I'm not going to address it. I already have. All right. There are requests for 3 exhibit.
I don't like that.
Is that his number? I know he signed it, but I do. I meant to tell them that. It's a signature.
Somebody, I'm going to ask that.
I need to know
It ain't going to matter, so what do
number
you keep
to
bringing it
tell
up for?
the parties who the 4th person is, because I'm not going to say the name on the record. They have a request for 3 exhibits, 15, 5, and
Y'all see him put his coat on, his coat probably stink, given that he ain't had a shower. I'm glad that they social distancing. He ain't got to smell his funky behind.
55. Number 11 is the 4th person.
You said 15, 5, and
55. So I can pull.
That
I was
mask
gonna say,
spray
I don't
stink.
know. I know 15.
15 is the map.
15 is the map, yeah.
Any objection to the map, sir?
Yeah, I want you to rule on everything.
She
Gonna
gonna
go
roll.
one by one.
She gonna roll on it.
So I'll start with exhibit 15, which is the map. What's your position on that, sir?
My position is at this point, what is the relevancy of the map?
Oh my God,
I
here
think
we
it's
go.
been seen a million times. I know it by heart now. At least that's probably the only one I know by heart.
Well, what's the state's position?
Let's wait this out.
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to
Exactly.
work through and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's
Exactly.
helpful to them in their deliberation.
Now watch this. Before the judge gives her ruling on that. That's do y'all remember when Darrell was questioning was it Detective Schultz or one of the officers? I can't remember verbatim, but I know the gist of it, where Darrell kept asking them what was their reason of reviewing or watching it over again or seeing it again. Remember, he would say, well, if you've seen it, why did you have to review it again? And I always say, well, maybe they wanted to be sure, upon reviewing that, so that way they could better have recollection of it. I used an analogy one time, and I do it all the time, and I'll say it again, that usually when I order food, when I'm ordering the food, after I pay for it, I don't just drive off. I review what's in that bag to make sure that what I ordered is correct. So that way I don't have to, you know, drive back around and have them change stuff. Had I looked at it, now I have an idea exactly, okay, they did the right thing. So now I can pull off. I do that all the time. So that's no different. That is no different than the jurors reviewing that map. So what if they saw it? Let them review to have better recollection. Let them review. You know, so I agree with the state, and I believe the judge is going to side with the state because it makes sense. Mr. Brooks says things that doesn't have any sense or any merit behind it. It's not strong enough. And so when the judge weighs between what he's saying versus the state just brings more potency to their argument as opposed to the weakness or the impotence of Mr. Brooks.
All right, I will send Exhibit 15 back
Of the map.
to the jury room. It is an exhibit,
Mm-hmm.
and there really is no reason not to send it back that has been
Exactly.
identified by the parties.
Exactly.
All right, the next exhibit is Exhibit 5. That is the photograph of Erica Patterson.
You need to see that the
Oh, I
damage he did
definitely
to her.
object to that.
Why not? Why?
Seeing as how it was supposedly two incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So
So wait a minute. Well, where did the black eye come from then? If it didn't happen, was she punched herself? She ran over herself with a vehicle?
I don't even. It's too dicey with that. What incident would five be referring to?
Okay, let's see what the state
One of
got to
which
say.
The
never
battery
happened,
count.
and then one.
Battery. You punched her in the
I
face.
don't even know what I'm looking at if I look at five.
Let's hear from the state. Okay. Let's hear from the state.
What's the state's position
Thank
on
you.
5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 6.
But so he's correct. The fact remains that it's battery. It's battery that has been alleged that he did, and the jury needs to see it. So him arguing that it didn't happen, that's bull.
77.
See why I'm confused?
Well, there is an amended information, and I clearly instructed the jury on 76 counts. Be that as it may, I'll find that